A contested divorce means that the parties either don't agree to divorce or to the terms of the divorce. Since New York now has no full divorce, it's very likely that if a party wants a divorce, he or she will get a divorce. Accordingly, divorce would only be contested due to a disagreement over the terms of the divorce. Such terms may include spousal support, which was formerly known as alimony, equitable distribution, which refers to the division of property and other assets, child custody, visitation, and child support. If one of the spouses have much less income than the other, the court may direct the spouse with the higher income to pay the legal fees and expert expenses of the spouse with less income. The typical contested divorce will usually involve the following process. The party who initiates the divorce action is known as the plaintiff. The plaintiff commences the divorce action by purchasing an index number from the county clerk and by filing a summons with notice. A divorce action may be also started by filing the summons and complaint with the county clerk's office. A process server then personally serves the summons with notice or summons and complaint upon the other spouse, who for the purpose of the divorce action is called the defendant. The defendant has 20 days to respond if served within New York. If served outside of New York, the defendant has 30 days to respond. If the defendant does not respond within the allowed period, the plaintiff may request a divorce by default from the court. If the divorce involves issues of custody, child support, spousal support, or equitable distribution, such issues must be decided by a judge after a hearing. In most cases, the defendant retains an attorney. It is also possible that the defendant will respond without retaining an attorney, which can be problematic because the defendant will most likely not know what to do. This can delay the process. The judge assigned to the case will no doubt urge the defendant to retain an attorney. If served with a summons with notice, the defendant will request a copy of the complaint. If served with the summons and complaint, the defendant must submit his or her answer. The defendant may also send the plaintiff the defendant's counterclaim and demands for spousal support, equitable distribution, custody, child support, and visitation. A request for judicial intervention, which is also known as an RJI, must be filed next. If a decision regarding an issue such as custody, support, or exclusive possession of the marital residence requires urgent attention, either party may request immediate relief from a judge. The judge's decision will be temporary, pending the final resolution of the divorce. The parties are required to complete and exchange financial net worth statements. The financial net worth statements are extensive and must include all of each party's assets and liabilities. The first hearing before the judge is known as the preliminary conference, also known as the PC. At the PC, the attorneys for the parties will discuss with the judge the issues of the divorce, which may include equitable distribution, spousal support, custody, child support, or visitation. If the parties agree about any of these issues, each agreed upon issue will be noted as resolved. The divorce will thereafter focus on the issues about which the parties do not agree. If child support is disputed, the judge at the PC may appoint an attorney to represent each child. The judge may also order that a forensic mental health professional interview the parties. The judge may rely upon the report of the forensic mental health professional to make his or her decision regarding custody and visitation. At the PC, if the equitable distribution of assets is contested, the judge may appoint one or more experts to appraise the assets. Assets that commonly need to be appraised include real estate, a business, pensions, and jewelry. At the PC, the judge will direct that discovery, which is the exchange of financial and other information, take place between the parties and will set deadlines. Depending upon the judge and the facts of the case, settlement discussions may take place at the PC. Even if a final settlement is not reached during the PC, the discussions may be useful towards resolving the differences between the parties. At the end of the PC, the judge will issue a PC order which will include identification of the issues in dispute and a timetable for the exchange of financial information. If the divorce has not already been settled, the next hearing in court is known as the compliance conference. As the name implies, the purpose of this hearing is for the judge to determine whether the parties have complied with the PC order. In addition, the judge will often discuss settlement with the attorneys. A settlement will often occur at this point with the urging of the judge. If the case is not settled, the next step in a contested divorce in New York is the completion of discovery, the payment of the note of issue, and the scheduling of the trial. It is common for a pre-trial conference to be held to see if any lingering issues can be resolved with the court's assistance. At trial, the plaintiff will present his or her case first. The plaintiff will present witnesses and submit evidence in support of his or her position. The defense has the opportunity to cross-examine each of the plaintiff's witnesses. At the conclusion of the plaintiff's case, the defense will present evidence in support of his or her defense and of any counterclaim that the defendant has asserted. The plaintiff will then have the opportunity to respond to the counterclaim if the defendant has asserted one. Based upon the arguments, expert reports, and the evidence, the judge will then make his or her decision. In many cases, a settlement is reached before the matter actually gets to trial. Once a settlement is reached, the attorneys draw up concluding papers, which they submit to the judge for approval. Depending on how far the matter has progressed, all parties may be required to appear before the judge to finalize a divorce. Once the divorce is resolved through settlement or trial, the divorce papers are submitted for the judge's approval. When the judge signs a judgment divorce, it is entered at the county clerk, at which point the parties are officially divorced. They may then obtain certified copies of the judgment of divorce. This entire process can take anywhere from several months to years, depending on how complex the matter is and how much the parties choose to litigate. For more information on contested divorces, call us toll-free at 855-625-0800 to schedule a consultation.